The sixth issue I'm going to address in our series on top 10 insurance issues for non-insurance lawyers are the negotiating terms and conditions of D&O policies, director and officers policies. And we selected D&O policies for two reasons. One, we've mentioned this in other presentations on this website, is the importance of D&O for our corporate clients. It's just one of the most valuable assets, corporate assets for any company. And number two, in our experience in negotiating on a renewal basis with underwriters, or even for purchasing insurance in the first instance for newer companies, we have found, based on our experience in this area, is that we have the most flexibility and the most ability working with the underwriters in negotiating terms and conditions and enhancing those terms and conditions in favor of our clients for coverage. So this is why we've selected D&O. So what happens when you are purchasing insurance or renewing insurance, you're negotiating terms and conditions? Again, you're relying on your insurance broker primarily. The issue with the broker, however, is the broker's not a lawyer or is not a practicing lawyer. So the broker's not aware of the most recent case law, right? What are courts? What are judges? What are juries? What are insurance companies and other corporate policyholders around the country saying about certain coverage issues, like the scope of coverage for a complaint or a subpoena, or the allocation of defense costs, or the exclusion for personal misconduct or criminal behavior or fraudulent conduct, right? We as lawyers here at Miller Friel, this is what we do every day. We are up on these issues either through our own clients and their claims, or we're canvassing on a daily basis what else is going on around the country. So that is something that we're bringing to the table when we're working with our clients and their brokers in trying to get the best terms and conditions. So with D&O policies, there's a few issues you should be looking at. The first is the definition of claim. You want to know, does it include just legal complaints and legal subpoenas? Can it be more informal demands, such as a consumer letter, an email from a disgruntled counterparty in a transaction? You want to know, does my coverage include coverage for the company as on its own, as a separate entity or defendant, or only individuals? How broad is your coverage? You want to know about some of those key exclusions. I mentioned just a minute ago, but your personal misconduct exclusions, your fraud exclusions. We have language that we consider to be state-of-the-art with respect to limiting those exclusions as much as possible. So for an example, you want to have language in the personal misconduct exclusions where it only applies if there's been a final, non-appealable order finding in fact that an insured committed fraud or acted unlawfully. And that final non-appealable order, meaning it's at the highest court available, right? So if you're in litigation, you've gone up to the Third Circuit, you've made a petition for the U.S. Supreme Court, it's been denied, then it's final. If you're in arbitration, the arbitration provision better say, if you get a ruling from an arbitrator, it's non-appealable, you can't go to court with it, then that's final. You need to be very careful. You have this very precise language in there in order to limit the scope of that exclusion. And there are other examples similar to the personal conduct and the fraud exclusion that we have worked on, really what we think is the best and most state-of-the-art, most favorable coverage terms for our clients in the D&O space.